So in New York, there's a warranty of habitability, and that's governed by Real Property Law 235C. Okay, what that basically says is that all properties in New York that are residential have to be fit for human habitation. Okay, it basically implies in a written lease or an oral lease, all right, every landlord-tenant situation, that the premises, again, are fit for human habitation. They are consistent with what they reasonably intended to do for that tenant, and that the premises are safe, right? They don't endanger a tenant's health, safety, or life, okay? So if your landlord tells you we're not bound by that, that's an absolute lie. Every residence has this protection with them, okay? So with violations, and I'll get into the examples in a second, violations of the warranty habitability are either defects with the property or their housing code violations, per the city or the town or the village that you're residing in, okay? The violations are looked at in an objective basis, okay, not a subjective. So what a reasonable person would consider this a defect or this broken or this damaged, okay? If the tenant feels that it's a violation, that may or may not be true, okay? If they're obviously subjective, they think it's not, or more serious than it actually is, okay? In order to have a violation, you have to tell your landlord about it, okay? Hey, there's a repair that needs to be made, this is defective, you have to put them on notice of it. Another one we're seeing a lot of is environmental factors, right? Mold, asbestos we're seeing a lot of lately, lead paint, that's being cleared up by the city and the county. They have a program, but we still see that. If you have like excessive smoke coming in from a neighboring unit, or noxious odors, or loud music, those will also qualify, okay, as breaches. The last one example is lack of security, all right? Your locks don't work, your doors to the exterior are damaged or broken, the windows are broken or they're painted shut. We see that a lot, so that's a fire hazard. A lot of properties don't have smoke detectors or carbon monoxide detectors, okay? Broken lighting. So these are some of the examples of the security, okay? The conditions that you're complaining about can be past conditions. Let's say you moved into a place, the condition is defective, it's already there before you moved in, you can complain about it because it's happening while you live there. Or if the condition arises once you moved in, obviously, again, that's in fair play, okay? So common examples of a warranty habitability breach, all right? Big one is lack of utilities or intermittent utilities, all right? So lack of heat, faulty electric, no hot water. Those are the big ones, okay? If you don't have those issues or you're having problems with those, you need to definitely contact your landlord and call us, okay? And I'll walk you through what we can do for you. Other issues are relating to structure. So if you have a leaky roof, your plumbing is defective, you have holes in the floor, holes in the ceiling, broken steps, you have a sump pump which backs up and you have sewage in the basement. If you have appliances that were supplied by your landlord and they're defective, they're broken, they don't work. Okay, those are some examples of the structural. You could also have an infestation, right? So rats, mice, cockroaches, bed bugs, any type of infestation, obviously that shouldn't be there, as long as you didn't bring them in, okay? If they're coming in from another tenant or they were there, the landlord's fault, you can make a complaint about that.
If anything.
The other last piece is what isn't a breach of the warranty habitability is if you're not a tenant, okay? If there's a squatter who's moved into a property legally, or there's a licensee situation. Licensee is where you move in with your brother who lets you live there for free, okay? They've basically given you a license. They've given you the right, to live in that place. You're not a tenant, that license that's given to you typically by a family member or a friend, can be revoked. So you technically don't have a complaint. You can't make a complaint in those situations. So you want to keep track of all the defects in the apartment, all right? And so you kind of make a log, like what room is the defect in? Where is it? Is it the bedroom, the kitchen, the basement, attic, wherever that is, okay? Then list what condition it is. Is it a leak? Is it mold? Is it, a damaged fixture, plumbing issue, okay? Write down and keep track. When did it start, okay? And then if it ends it got fixed, still keep track of that, okay? Even though the issue got fixed, you can still take action against your landlord and get damages or reimbursement of rent for an issue that only existed for a month or 2 months, okay? So even if it was fixed, you still have rights. Keep track of when you provided notice to the landlord and how did you provide it. Was it text, email, notice, verbal? And then make sure you document that, the issue. Take a video, take a picture, okay? As they say, pictures are worth 1,000 words, okay? And then lastly, we have a notes section. So if you made a complaint, the landlord says, I'm not fixing it, I need money, or I don't have enough money to fix it, make a notation of that. When did you have that conversation, okay? Nope. So whether we call it sit on your hand, whether you do sit on your hands and do nothing and you delay reporting it, it doesn't matter. That issue has to be fixed. Whether you report it 2 minutes later or 2 years later, as long as you're there, okay, that's a violation that needs to be addressed by the landlord. So there's no negative impact if you do delay, reporting that issue, okay? So when you discover a defective condition, what should you do? All right, first, you want to notify the landlord, okay, again, preferably in writing. Make sure you keep a record, of the date and time, okay? Also, when you notify the landlord, you're making a request to have it fixed. I want it addressed, I want it remediated, I want it taken care of, okay? You have to give the landlord the opportunity to make the repair. All right, you have to give them access to come in, all right? Typically, in New York, the landlord's gonna give you 24 hours notice. They send you a text message, they call you, what have you, say, hey, I'm coming tomorrow to make this repair, okay? The only way that typically is sped up, where it can be immediate, is if it's an emergency, all right? Gas leak, water leak, your landlord does not need your permission to come in, to the apartment to make that repair. You also don't need to be there, and I get a lot of people want to be there when someone's coming to fix their apartment, but if it's an emergency, you need that issue taken care of, so they would be able to just come in and make that repair, okay? We call it repair and deduct, okay? This isn't an option for most people who are on limited incomes or fixed income, okay? You're gonna tell the landlord, hey, I've made requests, I've made complaints, you're not doing anything, I'm gonna do it. Excuse me. So in this situation, if they still don't fix it, you can make the repair yourself. Excuse me. You can hire someone, but whatever you pay out, whether it's labor, materials, okay, keep track of your payment. Keep track of the invoice, keep track of the receipt. Because when the next time to come around to pay rent, you're now gonna deduct that portion of the rent, all right? So let's say your rent, just to use round numbers, is $500. You spend $200 to make a repair. You're now only gonna pay $300 that next time, okay? Give the landlord the documents to show what you actually paid, and then deduct it, okay? Significantly though, you can't just jump the gun and make those repairs. You gotta give the landlord an opportunity to make it, okay? You know, sometimes, thank you. You know, you gotta give them the chance to have their own people do it, okay? Typically, you will run into a problem where these people have maintenance men. They're not certified, they're not licensed, they don't know what they're doing. They make a garbage repair, okay? You know, you can report them to the city. They didn't pull a permit, they're not licensed in the city, they're not insured, what have you. And you know, the landlord couldn't get in trouble because they didn't have the right people fix it, okay? But if the repair is made, it's not done properly, you know, make that complaint again. Hey, your guys claim to have fixed it, they didn't. I want it fixed again, okay? Next option is break your lease, all right? If you are so disgusted with the landlord's inability or failure to fix these items, and you know you have somewhere else to go, you know, break your lease, give your landlord notice, okay? I'm done, I'm not putting up with this anymore, I'm moving, okay? What we recommend though is you have another place lined up before you give notice, okay? You don't want to get into a situation where, you know, you have a knee-jerk reaction, I'm leaving in 30 days, and then you don't have, if you gave 60 days notice to your landlord to leave, and you don't leave by the 60th day, your landlord could potentially charge you double rent for the period that you're there after you give the notice date, okay? Also look at your lease, okay? It depends if you're in a year-to-year lease, if you're in a month-to-month. Sometimes, you know, month-to-month, you only gotta give 30 days notice. You know, a year-to-year might be a 60-day notice, but in worst-case scenario, if you have a place, just don't worry about the notice. Just leave, go to a new place, okay? Chances are your landlords are not gonna come after you, all right? For that rent or the future rent, okay? When a tenant leaves, the landlord has a duty to mitigate their damages. They have a duty to find another tenant to replace you, right? They can't just do nothing and say, well, I'm gonna charge Mr. Smith all this rent money that he was supposed to pay until he left, okay? The court could say, no, you can't do that. You didn't take any action, you didn't market it. We're not giving you that rent money from the tenant who left. Fourth option is to sue your landlord. You can, if you're in city court, county court, Supreme Court, okay, you can actually have an action to enforce the lease, all right? Force that landlord to make the repairs. We typically don't recommend that avenue because it takes forever, okay? You need that repair done quick. You don't have time to wait. Courts, you know, depending on, you know, what the claim is or where you are, could take months and months, you know. So that's an option, but, you know, that's something we don't recommend. What you could do instead is you can do a small claims court action. If your damages are less than $5,000, you can go to city court. Anywhere in the county, even though you're outside the city, you still file small claims in city court. It's a $20 application. What you're claiming would be is, hey, I paid rent, there was all these defects with the lease and the property, I'm entitled to a credit back, okay? If there's a defect, the judge is gonna award you a percentage off the rent for every month that that condition existed, okay? It could be 5%, it could be 20%. The highest I've seen is no heat, which would result in a 50% reduction in the rent, okay? Every month that happens, you're getting that percentage. So again, if you overpaid, or if you paid all your rent, you would get a judgment against your landlord for the amount of your damages, okay? If you owe rent, let's say you owe rent and the judge only gives you a percentage which is less than the rent you owe, okay? You will then reduce your rental obligation. So if you owe $500 of rent, the judge says, I'm gonna knock off 200, you then would owe 300, but you would owe less than the full 5. The last option, it's probably the best option, is to file what we call an Article 7D petition, okay? This is a quick summary proceeding under the Real Property Action Proceedings Law, all right? You file an application in either county court, city court, or town and village court, all right? Not supreme and not small claims, okay? I've given you in your packet the order to show cause, okay, which is the document that would be signed by a judge, okay, and tells the landlord and you, this is your court date, this is the court time, this is the location. You need to come to court and explain why the tenant's petition should not be granted, okay? The petition, which accompanies the order to show cause, is where you lay out your facts, okay? On the tenant, this is the landlord, these are all the issues that I'm experiencing, write them all out, okay? Roof leak, rats, okay? Whatever that issue is, explain, this is the length of time. If you've had damages from it, you had to spend money on your own traps, you had to pay a roofer to fix the leak, okay? Lay it all in there, okay? And these don't have to be typed, okay? You can retain us to do it, we can file it for you, or you can do it on your own, okay? I've given you the forms, again, you can handwrite them in if you want to go that route and do it on your own, okay? If you don't have neighborhood legal services or another not-for-profit to represent you, okay, and you want to do it on your own, we've given you the forms to apply for what's called informal pauper status. It's basically Latin for poor person, okay? Depending on your income and your assets, the court will waive the filing fees, service of process fees, and what have you. Basically, you're allowed to do that court proceeding for free. The judge will sign the order to show cause. He will address the order that you're requesting to be in a poor person status. They sign it, then you take that order to the sheriff, and the sheriff will serve your papers for you, okay? With the Article 7D, the violations need to be either a warranty or habitability violation or a property code violation. You can't just, again, require the landlord to fix peeling paint or, stain in the rug or something similar to that, okay? Once you get the papers back, the court's gonna call you, hey, your papers have been signed, come pick them up, then you have to serve them. So in most cases, you're gonna go across the street to the sheriff's civil division office on West Eagle. Here's my order, I need you to serve these papers, okay? Typically, you have to give notice to the landlord 10 to 17 days before the court proceeding, unless the judge says otherwise. The judge can say, this is an emergency, you have 5 days notice, you gotta come to court, okay? If you guys serve the papers, actually we recommend that you do not serve your own papers, have a relative or a friend mail them. You can mail them certified regular mail, you can do them personal, okay? But have someone else drop it in the mailbox. Once they're served, if you get an affidavit of service back from the sheriff or your friend or family member, they're gonna fill it out. The affidavit of service is in the packet, you file it with the court, okay? To show that you gave proper notice, to your landlord. Then in your court date, you're gonna come with all of your evidence. Any witnesses you have, okay? You're gonna have a hearing most often right then and there, right? Judge, these are the conditions that I want fixed, that I want addressed. Here's my proof. I have videos, I have photos, I have text messages, emails, I have these witnesses who observed all these conditions, okay? And if, the judge will hold a hearing. If the landlord is there, they'll hear his side or her side. And then the judge will make a ruling, okay? The relief you can get in an Article 7D is one, a judgment ordering the landlord to make the repairs. And the judge is gonna give a deadline that those repairs have to be made in, okay? So a week, 2 weeks, 30 days, okay, what have you. They could stagger it. These repairs have to be made in a week. These repairs are in 2 weeks, okay? You can also ask for an abatement, all right? So let's say there's no heat, no hot water. Judge, I shouldn't be permitted or required to pay rent moving forward. I'm asking for an abatement. What the judge will do is say, all right, landlord, you're not entitled to any rent at all until these issues are fixed. So the landlord cannot then file an eviction proceeding because they didn't pay the rent because the judge abated that rent. The other thing you can ask for is a credit, okay? So this is where the percentages come in. Judge, I'm asking for 5%, 10%, 15% credit towards rent I've already paid. So either that comes back to you with a payment or you get a credit going forward, okay? Two things to watch out for, all right? When you do any of these options except for moving out, okay? Your landlord could come after you and file a non-payment eviction, okay? They didn't pay me rent, I'm entitled to the rent, I want that tenant out, okay? You're going to present your defense, you're gonna tell your attorney, I withheld the rent because the repairs weren't being made. This is the amount, this is the time period, okay? That is defense to the non-payment proceeding, okay? The judge, most times, is gonna say, yeah, that's a valid defense. They're gonna deny the petition for eviction based on non-payment, or they're gonna reduce the rent that you owe, okay? Now, earlier when I said, take the withheld rent and put it aside, okay? This is to protect you if the rent damages that you have, right, the credit or the abatement does not knock out all of the rent that was due, okay? So let's, again, $500 rent, you get a $200 knockoff, you owe $300. You're gonna have to come up with that $300 to pay it to avoid that eviction in the non-payment, right?
Everything.
So the only thing with Section 8, okay, if you get a voucher, okay, and there's two types of vouchers. One is one that is personal to you. No matter where you live, you have that voucher. You can pay and give it to any landlord, okay? The second type is a project-based voucher, where you're renting from a particular landlord who charges less rent because they get funding from HUD or the government, okay? But in those two situations, you need to comply, they're both income-based, you need to comply and provide your income, those types of things, okay? With the voucher, you could get in a situation where Section 8 says, we're not paying you rent because it failed an inspection, okay? The property failed, it's not suitable, it's not habitable, we are now cutting off the rent, okay? That's huge for landlords because most landlords want Section 8, they want the voucher because they're getting paid no matter what, right? If the client loses a job, they get injured, what have you, fall in hard times, they're not paying rent. But Section 8 is there, they're paying the rent as long as it's habitable. So they send a notice to the landlord, hey, your inspection failed. Until it gets up to snuff, we will then turn it back on. But yeah, other than that, everything else, is the same. Okay. For people who have vouchers, you need to do everything possible to keep that voucher. Because with the cutbacks with the federal government, if you lose your voucher, the waiting list is probably 5 years long. It's going to be tough to get that back. what typically happens in Buffalo is they don't file a non-payment, the landlord will send you a termination
This
notice,
coffee?
okay? Try and terminate your lease. If you don't get out by the time they say, they're gonna file a holdover eviction, okay? If you've made a complaint to the landlord, if you made a complaint to municipality, Department of Health, the city, what have you, before they serve the notice of termination, okay, there's a presumption that that's retaliation, okay? They're retaliating against you because you busted them, you made a complaint, you got them in trouble with the city, they're facing an order to remedy, they're facing a fine, all right? That's a complete defense to that eviction, okay? With that presumption is you have a full year from the date you complained, okay? You complained on January 1, if they serve you with a notice to terminate anytime within that year through December 31st, again, there's a presumption that's retaliation, okay? It doesn't have to be immediate, it can be within that year period. It is a rebuttable presumption, okay? So the landlord can present evidence that, no, I served this notice of termination because of this reason or that reason, but it's the landlord's burden to prove that it was not, in retaliation, okay? Once, you go to a hearing, if you prove the retaliation, then the eviction is stayed, for another year, okay? They could file a non-payment if you don't pay rent, but they couldn't terminate your lease, under those circumstances. So typically, again, just to summarize with the 7D, it's usually the best way to go. It's relatively quick. It forces the landlord to make repairs. It doesn't come out of your pocket, okay? We can represent you for free, or you can do it on your own and usually get the fees waived. But if you do nothing, the landlord's just gonna expect you to pay rent, okay? You need to take matters into your own hands, so to speak. Send this landlord a message, okay? Some tenants, we tell them, we just give legal advice. Hey, these are your options. I tell the tenant, go tell the landlord that you talked to an attorney. Grab their attention, because usually, okay, I don't want to get sued. If I evict, I'm going to get opposed in that hearing. You need to level the playing field, so to speak, okay? We typically would start off with a letter of representation. Okay, we represent so-and-so. It's our understanding that you're not doing this or you're doing this improperly. Get their attention. If changes aren't made, we're just going to continue to go up the ladder, okay? Those properties, if they have the federal funding, they got to comply with what they're supposed to do, right? Or they're going to lose funding. Right. So, but, again, an attorney letter goes a long way. And I hate to say that, like it shouldn't just be an attorney letter that works, but, landlords are going to blow off a tenant. They don't have money to hire an attorney, or they're not going to know their rights, right? So get an attorney on board.